Everybody, welcome back for another video. Today I have Seth Meyer, a business and construction attorney here in the New York City area. Seth, welcome, man. Thanks
Thanks,
for
Jerry,
coming
man.
on.
I've been following you for God knows how long, and you are probably the number one guy who's hitting on the construction content. So it's really an honor to be here with you today. Thank you.
Thank you, man. Awesome. I know we connected probably well over a year ago, maybe
Yeah,
almost 2 years ago, and we've been sending messages. So we finally get to jump on a video call. But construction law, especially in and around the major cities, is obviously always certainly a major topic. And having a good lawyer on your side is part of having a successful business, in my opinion. So I want to quickly talk about the five topics we're going to talk about in this video. We're going to talk about payment issues in construction contracts, which are common. We're going to talk about the common payment disputes and when to lien. We're going to talk about scope creep. At what point you need to get a lawyer involved. If you're constantly being told to do what you feel is scope creep or change orders, right? And the GC or the owner is refusing to pay, at what point do you bring a lawyer in? And then we're going to talk about utilization plans, how to get firms certified to be a minority company. And then we're going to dive a little bit deeper into that on how to keep your certification as well. We're going to talk about compliance with changing payroll obligations. For the sake of you being a lawyer here in the New York State area, I know you had mentioned every state is got its own challenges. So for this video, we're going to talk about New York State. And then we're going to talk about legal considerations in construction contracts. We're going to talk about key clauses that protect you in your contracts, and also the role of mediation and arbitration in resolving disputes. So we have a lot to cover. I'm going to try to keep this around 30 minutes or so. So Seth, let's start diving into the first topic, payment issues in construction contracts. In your opinion, or in your field, obviously, what are the common payment disputes you've been seeing? And then we'll dive into the next segment.
sure. So, Jerry, number one issue, contractors, subcontractors, anyone in the chain of construction is dealing with today is getting paid. And every problem, every issue starts and ends with money. Because if you get paid, you can pay your lower tier folks. You can pay your unions. You can pay your material suppliers. Without that, everybody starts complaining, starts raising issues, starts making demands. You get letters from the collections folks. You get threats of being liened. You get threats of bond claims if applicable. You get the possibility for a really bad day. And depending on the type of project and depending on the location, you could be looking at liquidated damages. You could be looking at audit fees. You could be looking at all sorts of problems that are only caused by one person and one person only, Benjamin Franklin and his inability to get into your pocket.
That's awesome.
Yeah.
Well, it's a great analogy. So, I mean, common payment disputes. I mean, are there some examples that you can kind of throw at us that maybe you've seen lately?
Sure.
Without
So,
getting too confidential, let me say.
so public and private are both have unique concerns, but they all kind of stem from the same thing, is getting paid for work on time. Every construction contract, for the most part, will tell you you have to get your requisition in by X date, and you're going to get paid 30 to 45 days later. The problems we see is what happens when that payment is delayed, whether a municipality hasn't released the funds, a private owner, private GC hasn't gotten paid off their loan, or any other reason. Those all cause significant issues. We have contractors who've done change order work pre-COVID that still hasn't been paid. And you're asking a contractor to essentially fund a job, which they're in the worst position to do it because they're the trickle down to the trickle down. And that causes significant issues. We have issues where parties dispute whether back charges are applicable, whether the work is actually covered under this contract, or is it change order work? Is it contract work? Is it work that you should have been doing anyway? And it's not done either to the owner or to the GC specifications, and they don't want to pay you. Or they took away part of your scope because they don't think the project is moving fast enough. Or they, or there's any other reason why money's just not coming into your pocket, whether not having it or not wanting to give it. And that causes all sorts of issues. And that really forces a contractor, either a GC or a sub, to consider, how do I get this money? And you really, that's going to be the biggest business decision a contractor can make on the job. Well, do I send a letter? Hey, where's my money? How long do I let it go? Do I think about liening the job? Every state has requirements of how long you can lien. For example, very, very broadly, on a private job, in New York, you have 8 months from your last work. In New Jersey, you have 90 days. So you really have to be thinking about these decisions as they're in real time, because otherwise you're going to be a step behind and you may have lost some of your leverage.
Yeah. Yeah, cash flow is probably one of the top 3 topics I always speak about. And I've had several of these videos just prior to you about cash flow specialists and financial lenders. And, it's so difficult to really understand how much cost to borrow money you need prior to a bid, because there's so much relying on, if you're a sub, there's so much relying on a GC and their scheduling. And I'll be honest, most GCs are messed up themselves, and they don't really understand how to plan out projects as well. So I'm hearing horror stories, even with some of my clients that I have now, where they're 90 days out, they're 120 days out, they're trying to get certain projects started. They have a whole list of change orders that, and we'll talk about this a little further on. They have a whole list of change orders that they feel that they need to be getting paid for. The GC doesn't agree because he or they think that the owner is not going to pay them, the GC. So it just becomes, it gets really messy. And I don't care how well you're planning out your projects. There's so many different people involved in each of this decision making that all it takes is that 1 or 2 people that don't agree with the predecessors or the successors of that decision making, where it just throws everything off. So you're talking about common payment disputes. At what point does a subcontractor say, you know what, enough is enough, I'm going to file for a lien? Because here's another thing too, is that this has been a big topic in my 20 plus years, and a lot of contractors are scared to file a lien for good reasons, because they don't want to burn a bridge with a GC who's feeding them 25-30% of their work every single year. So I understand where they're coming from, but at what point is enough enough? And at what point do you cut your ties with that GC and you file a lien? What are your thoughts on that?
A lien doesn't have to be the end all be all. And we've seen a couple of situations. We've seen the situation that you're dealing with, where if I lien the job, I'm going to lose that relationship. But we've also seen subs communicate with their GCs ahead of time. Hey, we haven't been paid. My rights almost expire, and then I can't get money. Then I lose this piece of leverage. And the GC will come back and say, hey, sub, I haven't been paid either in 6 months. So it could be to the GC and the sub's benefit to lien. So I had a sub who did a good amount of work, and they hadn't been paid or communicated with in 6+ months. Their lien window almost expired. We got that lien in. It noticed the GC and it noticed the owner. And then the owner comes out of nowhere and says, why are these issues? And the GC goes to the owner and says, you haven't paid me, so I can't pay these guys. And it opens up the conversation. So yeah, a lien stinks. It's a cloud on title. And you hired a GC, and now you have 2 brothers painting coming on and filing a lien for $100,000. The owner doesn't know who they are. Now you have the owner's lender saying, why is someone clouding title? Why is someone saying that they may foreclose on this project? And it really starts that conversation ahead. Says, hey, wow, we really need to do something here. Maybe our policies and procedures aren't right. Or maybe we're sleeping on the sub because we think they're not going to do anything. They're the guy, it's get along Charlie. Charlie's always been here to make sure the project goes right. But Charlie's got to get paid. Charlie's got to feed his family, and he's got to pay his workers, because then they're going to make a stink. And a lien is very powerful. And we've seen great success. And here's another thing. We had done work for a a material provider had done great work for a GC. The GC went out of business, filed for bankruptcy. So what's the sub going to do? Are they going to eat that? No. They lien the job. The owner got involved and said, okay, I have to pay this sub because they can make life very difficult for me. And now we're going to have to fight this for what? They delivered the material. 100 boxes of nails were delivered to the site. No dispute. They got to get paid for their nails. So if you by liening, you preserve your rights and you live to fight another day. Maybe the relationship is strained. Maybe they don't work together again. But at the end of the day, we have to see how do we protect our client and how do we get that money in-house so they can live to fight another day.
Yeah, and communication is critical, like you said. I mean, I would probably, and tell me if you disagree, but I would put it in writing multiple times, like 3 times. Say, hey, listen, this is where things are going right now. If I don't get paid, just picking up the phone all the time. So at some point, you got to put it in writing to have that backup. But can I ask you something? So if a sub files for a lien with a GC, right, and especially in the public world where being bondable is really big. How does that affect the bonding capacity of a GC if they get liens filed against them, or does that have any impact? I mean, what are your thoughts on that?
So it's a really interesting question because public liening is very different than private. When you lien on the private side, you're leaning on a piece of property. When you're leaning on the public side, and specifically in New York, you're leaning on the project funds. Basically, the DOT set aside $3 million for this project. Subcontractor says, I'm owed $500K. They attach their lien to that money itself and say, you can't let go of that $500K until I'm paid. Now, what owners GCs on projects will do is they will bond that lien. So what they can do is say, great, that subcontractor bond lien the job, they're entitled to do it. As the owner, I can bond that lien. What it says is, we could take the lien away, and this company, the surety, is going to guarantee that $500K. It's a separate product aside from a payment bond or performance bond, which is another useful tool for a sub to use against the GC. And if you're a GC, to make your subs have bonds, it's very strong to ensure that your sub is maintaining its obligations.
Yeah. Wow. That's
I mean, if a GC, most public owners will require their GCs to have bonds, payment and performance bonds, to make sure the job gets done. And if it doesn't get done, the municipality has recourse against somebody. And we're seeing more and more that general contractors are requiring their subcontractors to have payment and performance bonds. And it's sometimes used to the GC's advantage that if a sub isn't doing a particular work the way that the GC likes, they're going to say, well, if you don't do this, or you don't fix that, or you don't come here, we're going to call your bonding company. We're going to make a claim that you're not performing. So it can be used as a sword as much of a shield. So
that's a relationship you want to keep solid with your bonding company. Sorry, go ahead.
Bonding company, bonding company is your license to do public work.
Yeah.
It's exactly. Being able to do the work is great. Being able to comply with obligations is fantastic. But if you don't have a bond, none of that matters, because the public owners want to make sure that you can finish the job, and if you can't, someone else will. And if you're certified, and it's also a badge of honor for a contractor. If they have a bond, your word is your bond. No, your bond is your bond. And if you have that bond, it says, I have been through the ringer. And that ringer, I have come out, and I am good. I am good to do this work. I have a track record, and I will bring you project success.
I have a client right now, and and we have aggressive growth plans. And I said, you gotta pick up your bonding capacity, because when you go and you start bidding with these with these larger GCs, for you to be able to tell them that you're bondable to X amount of dollars, I mean, that is huge. That's
Mhm.
huge. And,
Yep,
and you just kind of helped me solidify that.
right, and then, to what you're talking about on the payroll, the dollars in, dollars out cash flow, you have to make sure that you can collateralize that bond.
Yeah.
So as you're looking to grow prospectively with, oh, we're going to take on bigger jobs, you have to make sure your reserves are there to take on that work. Because, many bonding companies won't let you take out an unsecured bond. They want to make sure that you have real property, stocks, bonds, something else behind that bond in the case of a non-performance.
Yeah.
So it's as you grow, it's growing your bonding also means growing your reserve.
Wow. That's great. Great point, Seth. And that's great. I want to start moving on to the next topic, but we kind of already beat it up a little bit. But let's kind of get into the next topic of scope creep and change order, and possibly you can tell me one or two some examples you've seen of at what point does a subcontractor or even a GC to an owner
Mhm.
get a lawyer involved, to an attorney involved, to say, hey, I need help. I need help because I'm not getting paid. I'm not getting paid. I'm doing all this work there. Maybe they're threatening that they're going to throw me off the job unless I keep doing work that I know is not part of our contract. So maybe you can expand on that a little bit more.
Sure. So I don't want to jump to our last topic first, but it also hits upon here. What the contract says matters a lot. And who you help negotiate that contract with matters a lot. Because if you're just looking at the amount I'm going to get paid and when I get paid, game over. You've already lost. You have to know this contract inside and out, like it is your Bible, your guiding light on a job. And you want to get your attorney in there early. You want your attorney in there saying, hey, these are things we can change, these are things we can change. Change orders are a very important area to know, understand, and how to use it to your advantage. So if a sub is saying, this isn't part of my contract, the GC says, yes, it is. No, it's not. Okay, so what's our provision? What does the contract say? Contract says GC can tell you to do this work. You could do it under protest. You could do it on dispute. This way, you're backstopping yourself, and you get your lawyer in there early and often to help you craft those letters to the GC, to help you outline your timeframes. Oh, we'll see a lot of contracts. You have to let us know within 72 hours whether this is a change or this is a delay or this is something else. At the first blush, I'm getting in there if I see this contract before it's signed, and I'm jumping up those provisions. How are you going to know today that the plumber not coming to work means you have a change condition? We want to build that out so you can let that grow. So you want to get your lawyer in there early so he could counsel you on how to respond, how to position yourself, and how to document up the chain. So if there's an issue later on, you're fully protected.
Right. And again, this goes back to what we talked about before. This is about proper communication as well.
Sure.
It's communicating, putting this stuff in writing as much as
Mm-hmm.
possible. And you don't necessarily need to get the lawyer to start writing these letters to a GC or to an owner right away. You could also call upon a lawyer to get your own personal legal counsel on how to approach it on the back end of the
Sure.
deal as well. Because again, I know what people are saying right now. Yeah, I'm gonna keep having my lawyer write these letters, and I'm going to be biting the hand that feeds me, right? You're not biting the hand that you feed that feeds you if you're communicating properly. But yeah, I mean, at some point, if that hand that feeds you is giving you 20% of your work, but yet they're refusing to pay you, and you're constantly waiting 6 months to get paid, and you're doing all this free work, and you're not making the profits, you're not getting the cash flow. At some point, you got to cut ties with this GC as well.
So Jerry, I'll tell you, you hit on something great. The relationship, right? The lawyer, a good construction lawyer, for the most part, is in the background. Because I went to law school.
Great.
If I try to use a hammer, I'm gonna hurt myself and 10 people around me. It's the same applies to dealing with construction relationships. I can help coach a client on what to say. I could even help write the letters, but unless they've gone legal first, I try to say, guys, keep the lawyers out of it. Your best your best bet with a lawyer is to be there guiding you, helping you. Keep those lines of communications open.
Consulting, advising.
It's consulting, it's advice, but it's also positioning for the worst case scenario, right? Because in 3 years, if you're in court and a judge is saying, hey, where's your notice? Oh, me and Paul talked about it on the side. We were gonna, we were texting, we were gonna make it work. Judge is gonna say, that's great. What does that do for me? Oh, but judge, yeah, we sent the letter. We sent the letter as required by the contract. We did it. Now it shows the judge, 1, they read their contract, 2, they know what they're doing, and 3, they made sure to preserve their rights. No one needs to know behind the scenes that the lawyer was helping them. No one needs to know that the lawyer was involved all the way through. So if it goes nuclear and it goes legal, you have an attorney from the other side coming in and they're trying to tell you this, that, and the other thing. You were there from day one helping your client. So you know what it was. So you have the institutional knowledge and the legal knowledge, and you put yourself in position to win.